Hi, everyone. I'm Jennifer Rodgers, sitting in again for Harry Littman. And today there's big legal news. Sidney Powell has pleaded guilty. Sidney Powell, the Kraken, one of the lawyers who was working on behalf of the former president to help overturn the election results, who was charged in the Georgia election interference case. She has pleaded guilty on the eve of her trial, which was scheduled to start next week. She was one of two defendants, along with fellow attorney Ken Chesborough, who decided to assert their speedy trial rights and go to trial within a few weeks. So they're scheduled to start on Monday. She is now out of that case. As part of her deal, her guilty plea, she will cooperate, and she's agreed to testify truthfully against other defendants in the case. So that's the headline. That's the big news. So what is the deal that she got, and what does it mean for her? What does it mean for the other defendants in that case? And what does it mean for Jack Smith's election interference case, the federal case out of Washington, D.C.? Let's talk about all of that. Okay, so what deal did she get? She has pleaded guilty to 6 counts of conspiracy to commit intentional interference with performance of election duties. These 6 counts are misdemeanor counts, meaning they carry a maximum sentence of 1 year in prison. And 6 years of probation is the agreed upon sentence. So even though she could, in theory, get a year for each of these counts, she won't, according to the deal. She will get probation. She'll also pay a fine and restitution. She wrote a letter of apology to the citizens of Georgia, which is an interesting penalty. And as I said, she will testify truthfully if they decide to call her. So this is why prosecutors charged this case as they did. They charged it with very serious racketeering charges, which are felonies and carry relatively high prison sentences, but they also charged other offenses as well. That gives them the flexibility to plead people out, and the flexibility to plead people out really cheap, as I think they did here, if they want them to cooperate, slightly less cheap maybe if they have a plea agreement that is not a cooperation agreement, but it gives prosecutors that leeway to get people out of the case, which of course they need to do. Prosecutors can't possibly try every single defendant on every single case they charge. The system would be overwhelmed by that. So that's how they make cases and bring them down. The first plea in this case was by a defendant named Scott Hall, who was someone involved in the Coffee County voting machine incursion that also involves Sidney Powell. So the fact that he pled first means that she really was in trouble, because he could testify directly about her involvement and her leadership of that part of the scheme. And so it's not a big surprise in that sense that she went out, given that he had pled guilty. So Coffee County, again, was where they seized and illegally obtained access to voting machines in Coffee County, Georgia. And took that voter data because they were looking for some sort of support for the argument that there had been voting machine manipulation or tampering or fraud. So what does it mean that prosecutors made this deal? Well, they clearly think that her potential testimony is valuable to them. It is a huge gift to Powell, but prosecutors wouldn't do it unless they were getting something out of it. It shows it's important to get out early, to get out of a case early before everybody starts to cooperate, because deals only get worse as you go on in time, as you get closer to trial. So one thing prosecutors will have to think about, though, as they will with any cooperating witness, is her credibility. Sidney Powell made some really outrageous statements having to do with this case and with election interference generally. She was sued by Dominion very early for libel and slander, and those cases continue. She filed some of the more egregious and unsupported cases that the campaign brought, alleging election fraud. And so she's got some things to answer to. I mean, she's supported QAnon theories, said things about the Clintons and Hugo Chavez and George Soros and others manipulating the election. So, if I'm a prosecutor, one of the things you have to think about is you put this person on the stand and they've got all these wacky statements out there, including, by the way, an important piece of evidence against Trump saying that he acknowledged that she and her theories were crazy. Is this person really credible? Even if you think that they're telling the truth as far as their involvement and others' involvement in these cases, you have to think about how they're going to come across to the jury. Okay, so what does this all mean for her and for the case and for Jack Smith's case? Well, for her, of course, it's good news. She got out pretty cheap without any prison time, without any felonies, which are good. She is a lawyer, and one of the challenges prosecutors face here in this Georgia case is that everyone they've charged, not everyone is a lawyer, although a lot of them are, but they're all people who have never had this kind of contact with the criminal justice system before. Anytime you charge people who are professional people, who have some sort of professional license like lawyers do, or who are politicians, these are people who thought that they never in a million years would have gotten arrested for anything. It's very hard for those people to plead guilty to a criminal offense and face the professional consequences, maybe losing a license, the reputational consequences, losing their positions, their status in the community, so on and so forth, and even think about the notion of going to prison. So they have set themselves up with 19 defendants, all of whom, are more reluctant than people who might have had contact with the criminal justice system in this way before. So for Sidney Powell, she's a lawyer. She presumably doesn't want to lose her law license. She actually has been battling on a couple of fronts in Texas and in Michigan on this score. So what does she do here? She pleads guilty to misdemeanors. That's important because a misdemeanor is better than a felony if you're trying to save your law license. And her lawyer already has made a move to try to get these crimes classified by the court on the conviction record as not crimes of moral turpitude. Moral turpitude is a legal phrase of art that is something that a lot of licensing bars in different states use as a standard. If you're convicted of a crime of moral turpitude, whether it's a felony or a misdemeanor, you can lose your law license. So these are all moves on her part to try to save her law license. So that's why this plea makes sense in that respect. Will she testify against Kenneth Chesebro starting next week in the Georgia case? We don't know. There's actually not a lot of overlap between the two of them when you read the indictment. Sidney Powell was involved in a lot of the filings of the frivolous lawsuits trying to challenge the election. She, of course, was very involved, as we've said, in the Coffee County voting machine incursion. But she didn't seem to have contact with Kenneth Chesebro that we can see in the indictment. So it's unclear how they would use her testimony in that case. They could use it as background and kind of talking about how the scheme took shape. I'm not sure whether they will or not. I mean, Kenneth Chesebro made a motion to sever his case from that of Sidney Powell, arguing that there was no overlap between them. He lost that motion, but that doesn't mean that they are so close that they would actually use Sidney Powell against him when they might have better evidence, documentary evidence, and other witnesses who could do a better job. So we'll have to see about that. What does it mean for the other Georgia defendants? Nothing good. Nothing good, particularly those defendants involved in the Coffee County incident and those defendants at the top of the indictment, Donald Trump, Mark Meadows, Rudy Giuliani, anyone who was really one of the architects of the overarching scheme and who would have been at that famous December 18th meeting in the White House when there was yelling and screaming about what they could and couldn't and should and shouldn't do. She can testify about all of that and, what they were planning, what they were doing. So I think for many of the defendants in the indictment, having her on board as a cooperator is a very bad thing. Notably, something that Harry raised in an email this morning and that I'd been thinking about is this issue of attorney-client privilege. She had previously seemed to be taking the position that she was one of Trump's lawyers. She was introduced that way by Giuliani and seemed to be, acting as one of his lawyers, one of the campaign's lawyers at least. Certainly when she was filing those lawsuits. She said yesterday through her lawyer, and this was kind of a tip to what she was going to do in cooperating, that she actually wasn't acting as one of his lawyers, trying to separate herself from Donald Trump and this scheme in a broader sense. So that's suggesting she's not one of his lawyers. What does that mean? That means they don't have attorney-client privilege. And that he couldn't use the advice of counsel defense with respect to her. I don't think he will accept that. I think he'll assert attorney-client privilege. They'll have to litigate that issue as we move forward. But probably it will end up going the way of many of these arguments in this litigation and others, which is that the crime fraud exception will overcome the attorney-client privilege here, I think. But let's look out for that as it moves forward. Finally, what does this mean for Jack Smith's case, the federal election interference case out of Washington, D.C.? Well, this won't directly affect that. I haven't seen her plea agreement, but I'd be shocked if it said anything about her cooperating with federal authorities. They typically don't work that way. So I think probably, Jack Smith and his team will just have to evaluate her as they would before, but knowing a few important things. One, she's willing to cooperate, right? She's already kind of gotten over that hurdle. So that's a good thing if they think about wanting to make her a cooperator. And remember, she's one of the unnamed co-conspirators in the indictment, co-conspirator number 3, I think. So she's really important to that case. So they can think about whether they want to use her, understanding that she has some vulnerabilities as a witness with her prior crazy statements, as we've talked about earlier. They'll also have a good sense of what she's willing to say and what she will say. And when she says things on the record for prosecutors, particularly if she testifies under oath at trial, they'll know that that's solid, so that if they call her, she won't be able to say anything inconsistent with that. If they did, then she could, if she did, then they could enter that statement into the record as it is. So it gives them some more options as they work through their case that charges just the former president. They can think about what they want to do with her, whether they want to try to immunize her and bring her as a witness in that case as well. So that's where it is. Kenneth Chesbrough is still out there. He apparently rejected a plea offer of a felony count, the RICO count, yesterday or the day before. So he's still barreling towards trial next week. Hopefully, we'll see that all play out. I certainly will be watching. I'm sure you all will too. And I'm sure we'll be talking about it as well. So I'll talk to you later.
Hey everyone, Harry here. Hope you're enjoying the content from all the friends of our channel, great experts in their fields all. I want to thank them for stepping up to the plate while I'm away. I'll be back soon, and I'm looking forward to resuming the daily videos. Talk to you later.